All right. Well, hello, inventors and entrepreneurs. My name is Courtney Laskowich. I'm the Managing Director of Inventors Groups of America, and welcome to Inventors Online. Thank you, everyone, for coming to this very special Saturday event today. IGA was founded in 2017 by Stephen Key and Andrew Krauss. IGA's goal is to teach individuals how to best commercialize their product ideas, as well as strengthen and support inventors groups throughout the nation. We have a directory of local and regional inventors groups on our website, whom we meet with every month. And if you are located near one, we highly encourage you to join. We'd love to hear your name and what state or country you are from. So go on over right now, open up that chat box, and let us know. Of course, please do not disclose anything that is confidential and not already publicly available. Of course, our meeting is being recorded and will be harnessed on our website and YouTube channel soon after. Feel free to change your name in the participants panel. Choose to be in gallery mode so you can see everyone on this meeting today. And though it is not required, we would love for you to turn on your video so we can see our beautiful community today. Is anyone new to Inventors Online? If so, go ahead and flash your hands in front of the screen. Look at this. All right, nice. Welcome, welcome. Welcome to all of the newbies here at IGA and Inventors Online. Now, today, our honorable guest speaker will be talking about the value patents offer to independent inventors. Alongside our special guest moderator, get ready to get some insight into IP and dive deep into the patent waters. IP is such a hot and sometimes infuriating topic, and the more we educate ourselves, the better we can make informative decisions for us as well as our products. Of course, please stay on till the very end to learn about our giveaways, very kindly provided by Ward Law Office and Kevin Prince, who's on with us today, of Quick Patents, and how to get, of course, Stephen's book, Sell Your Ideas with or Without a Patent, at the end for free. So, without further ado, let me introduce our revered speaker, a man of many talents. He served as the Undersecretary of Commerce for Intellectual Property and Director of the United States Patent and Trademark Office from 2017 to 2021. He has been a staunch advocate for inventors in his many appearances speaking about the importance of the US patent system. In 2020, he oversaw the sharpest declines in trademark application history due to COVID-19, but also observed in September 2020 being the highest month of trademark filings in the history of the USPTO. He is also a mechanical engineer and an intellectual property attorney. Give it up for the very honorable and quite humbling Andrei Iancu. Thank you so much, Andrei, for coming today.
Thanks for that incredibly generous introduction, Courtney. Great to be with you all.
Absolutely. Thank you so much. We really appreciate spending just a little bit of your Saturday today with us. Of course, our moderators of the day will be Stephen Key, and our special guest moderator is a patent attorney and a leading commentator on patent law and innovation policy. He has twice been named one of the top 50 most influential people in IP by Managing IP magazine. He is the founder of IPWatchdog.com, and according to IAM magazine, he is one of the top 300 IP strategists in the world. Let's hear it for Gene Quinn.
Hello, everybody. Pleasure to be here with you today.
Thank you so much for coming. We really appreciate it. And of course, because this is a hot topic, please type in your questions early in the chat box. And towards the end, we will go ahead and unmute you to ask that question. As usual, please be respectful of our speakers by keeping your questions on topic and timely. So without further ado, Stephen, let's go ahead and get into it. Would you like to start us off?
Well, thank you very much, Courtney. And I'm proud to say I received a patent just the other day. And this is over 20. I'm not quite sure how many I have now. And I have to say, this is absolutely one of the most beautiful covers I've ever seen. So I want to thank Andrei for this. I know he had a big part in this. It's wonderful. Thank you very much.
Congratulations, Stephen. It's always a big accomplishment to get one of those. It takes a while, as you know, but good job.
Well, thank you very much. I know, looking back, the first one I received over 20 years ago, I was very proud, of course, of that one. And it doesn't get old. Even the one I received just the other day, I'm just as proud as the first one I did receive. And that's why it really today is really an important day for me to really understand the value of patents today. That it, what is it? How does it impact that independent inventor today, those patents? Because I've used the patent system. I believe in the patent system. It's worked for me. But the question I'm having, because there's a lot of noise out there, Andrei, as you know, that patents don't have the value that they once have. Is this true in your opinion?
Well, so patents, historically, there's always an up and down type of an effect in the patent system over the span of history. But if we just elevate ourselves to the 30,000 foot level or 100,000 foot level, patents are, in principle, extremely valuable commodities. Let me just step aside for a second from an individual patent and just talk about the importance of patents to the United States and put it in the context of history. The patent system is born of the US Constitution. It's Article 1, Section 8, Clause 8 in the Constitution that gives Congress the power to create a patent system and the copyright system, actually, to promote the progress of science and useful arts by giving to inventors and authors their exclusive right to practice what they have come up with. Amazingly enough, the word right appears in the body of the US Constitution just once. Only once. This is putting aside the Bill of Rights. But in the body of the Constitution, the word right appears only once, and it's with respect to intellectual property rights, to the patents and the copyrights that are provided by the Constitution. It was that important to the founders. And it actually they were brilliant in many ways, and they saw that that was key to the United States to grow and develop. Now let's put things in history a little bit. And some of you who've heard me speak before, you might have heard my views on this, but think about the course of humanity. Humans have been on this planet, for tens or hundreds of thousands of years, depending how you count. We've organized in societies around the globe, certainly for thousands of years, right? We've had the ancient Hebrews, Egyptians, the ancient Chinese, Mayans, Greeks, Romans, and so on. But if we were to get together just 200 years ago, obviously, we wouldn't be doing it over Zoom. We would be in a hot and humid warehouse, probably here in Washington, D.C. Just 200 years ago. We'd have arrived here probably by horseback. If you wanted to communicate with someone, you wouldn't use your cell phone. You would probably have to send a carrier pigeon or Paul Revere on horseback. Anesthesia did not exist, right? Best case scenario, if you needed anesthesia, was a shot of whiskey. And that was just 200 years ago. In other words, the state of the human condition when this country was founded was approximately the same as in antiquity, in ancient Rome. Okay, so what happened? Well, for the first time in human history, innovation was democratized. And the founders, Jefferson in particular, together with Madison, they saw that what you need is a system that's accessible to all, that it is not reserved only for the rich, not reserved only for those that are friends with a crown, and not reserved only for those that can have factories and manufacturing at the big scale. Those were all conditions in medieval England. All that was done away with. And since the country was founded, the system has been open to all, at least theoretically. And look at us now. The progress of technology has been unprecedented, and it keeps going on and on. Now, that's at the grand scale. For each individual person operating in the patent system, things are not necessarily that simple. It is not easy to get a patent, and we'll talk through this process here. In my view, it shouldn't be easy. It's a very valuable instrument once you have achieved it, and it gives you the exclusive right to practice what you have come up with, and therefore the rest of the world, or at least the rest of the United States, is not allowed to practice. So the Patent Office takes that very seriously and scrutinizes your application to make sure it complies with all the rules and regulations. Now, so we can talk about what it takes to get there, but once you have a patent, your fundamental question, Stephen, is how valuable is it? Well, we know from many different statistics, in general, it is extremely valuable. Not to everyone and not to every technology out there, and for some more valuable than others, for sure. But as a general principle, we know that a startup company that receives its first patent, the percentage increase in its sales in the subsequent 5 years is 36 percentage points higher than if you did not get a patent. And similar statistics for the increase in employment of that startup. For the individual, it gives you credibility to go and meet with other people. It gives you an instrument through which you can do deals and license with other companies, potential manufacturers, and the like. And obviously, the ultimate is if you can make your own product, you can, at least theoretically, exclude others from doing the same thing, and you have a limited period of time in which you have exclusive rights to that field that you have invented. So, so let me stop there. But the benefits to the individual, as well as the companies they're in, and the community, society they live in, historically have been innumerable.
I want to continue a little bit here because I think a lot of us recognize the value of a patent, and that's why we're pursuing that patent on our invention. But sometimes we're a little discouraged in thinking that if we cannot enforce that patent, what value does it have?
Yeah.
Could you comment a little bit about that? Because I know big companies can probably take more advantage of the situation because of their resources, where us individuals, yes, it does give us credibility, allows us to raise money, maybe get meetings, but at the end of the day, that protection that the government's giving us, how can we utilize that if we cannot afford to?
Yeah, well, so look, a patent is useful if you use it. If you get a patent and it's a beautiful cover like Stephen has, but if you put it on the wall and you just use it as decoration, well, you get some pleasure out of looking at it every now and then when you walk by, but its real value is when you use it, whether through licensing or practicing your own. And in the end, if somebody else tries to do the same thing, enforcing it in courts. And you're right, enforcing a patent in courts is not easy, and it's not cheap. And for the patent owner, there are significant hurdles. But what it takes is, you have to find counsel. Usually, you have to file a lawsuit, and then you have to prosecute that lawsuit to its conclusion. The other side will always have defenses. The other side will say, first, that's not what I'm doing. I'm doing something different. I'm not doing what you invented. The other side will also say that your patent's invalid. So there's going to be a validity fight over the patent. The other side will say the patent office made a mistake. It should have never issued that patent. Now, the reality is, some folks argue that the scales are tilted against the patent owner in today's world, that the laws put up so many hurdles that it's very difficult for a patent owner to actually litigate a patent through conclusion and succeed. But look, the reality is that folks litigate their patents all the time, and they succeed a meaningful portion of the time. It's not cheap, but we can talk about ways of doing it, even if you don't have your own funds.
Well, that's what I want to go to next, because at the end of the day, it is difficult. But if you do license it to a large company, maybe they have the resources. But let's talk about creating that patent that has value, right? To maybe stop those companies that do want to litigate or do want to copy it or do want to take it, because I think we're not talking enough about that. Gene, I want to get your opinion on that, about what can we do as inventors to make sure that whatever we file gives us a better chance if there is a potential litigation, or maybe we'll stop someone from trying to take it.
Yeah, and if I could just take a half a step back and address the point about I see in the comments and questions, and what you've been talking about is, the patent system, is it bad? Is it not working for inventors? Is it detrimental? Should you be applying for patents and all that sort of thing? The one thing I always caution, particularly independent inventors, to focus on is, or perhaps not to focus on, is really the way to say it, is all of the stuff that you see where the patent system is going to hell, quote unquote. So much of that deals with software and life sciences, dealing with, biotech, and to some extent, very high tech stuff. The type of thing where there is not nearly the uncertainty, not nearly the problems, is with the areas that almost all of you are inventing in. Now, if you're inventing in software, then, you need to keep an eye on that stuff. If you're inventing in life sciences, which probably none of you really are, keep an eye on that stuff. But for most of you, you're inventing in areas which are not problematic. That's number one. So don't let the issues that are out there in the patent system at large discourage you. That's the first thing. The second thing is, the question about, if you don't have the money to litigate, what good is a patent? That puts the cart way before the horse. So I know a lot of you are we, well, first off, Stephen, are we talking to all your students or people who are familiar with your book, or who is our audience here?
What I think is really interesting, Gene, is that you said that I think most inventors that are here today are not in the high-tech field.
Right.
They have everyday inventions. Maybe it's in the kitchen or hardware or pet or DRTV. It's consumer products.
Yeah.
And I don't see problems there.
No. And the reason that I was asking how familiar they are with your philosophies is because if you follow Stephen's philosophies about filing a provisional patent application and continuing down the path of trying to get a licensing deal, and then if you don't get a licensing deal, or you're not able to find anybody who's going to buy the invention, or if you're going to go down the manufacturing path yourself or selling path yourself, cut your losses and move on to what's next while you still have some money in the bank. Don't spend every dollar on something that's not going to work, because it may be your next invention that's going to be the one that hits the home run. I mean, take, for example, Josh Malone, who bunch of balloons, that was his, seventh or eighth invention. That was his grand slam home run. Now, if he had wasted every penny he had on his first inventions, he would never have had any money to pursue the one that actually worked. So you have to be able to cut your losses at some point in time, so you move forward with your inventions so long as they remain economically viable. And the reason that that's important is, I always like to tell people, is don't get a patent on something that you're not already going to otherwise make money doing. If there's nobody out there interested in your product, nobody is going to be interested in your product simply because you got a patent. Okay. So now if you have a product that people are interested in, now what you need to do is you need to be very serious about that first filing and that provisional. And I am the quick answer here is, drawings are worth their weight in gold in that first filing, because anything depicted in a picture and understood by somebody who looks at your filing is going to be considered disclosed. And then if you do what best practices are, you're going to describe what each figure shows in at least one paragraph. Now, hopefully more than one paragraph. And that's before you go through any of the other parts of the patent application. So you want an application that's going to describe your invention from a big picture standpoint, like an umbrella, and then all of the little pieces and parts underneath that umbrella. So you want broad protection, and then you want very specific protection, and everything in between.
Before we get too far into that, Andrei, I have a question for you. The patent system works, doesn't it?
Yes, I believe that the patent system works well for its intended purposes. Now, of course, as I said, it's not necessarily easy, and sometimes you go through the motions and you do what you think is right, and the office does not give you a patent because somebody else invented before you, or the patent office does give you a patent, and then you sue somebody, and then you find out that there is some prior art out there that you didn't know about beforehand, and the patent's invalidated. Having said that, at the higher, at the highest levels, the patent system does work. It's always worked, and it does actually improve steadily over time. We have to make sure the inventors, the applicants, you have to make sure that you put forward your best application possible, and the attorneys helping them have to make sure that they help navigate all the rules of procedure appropriately. But once that's done, I do think there's tremendous value to obtaining a patent. I do want to emphasize, you don't always need a patent. All right, and you need to think about all the reasons why you might or might not, and you need to, if appropriate, talk to counsel or to folks like Stephen or Gene and so on. But here is what is important to do every time you invent something, and probably on day one, is to think about getting a patent. You have to consider at a minimum whether you should apply for a patent or not. You might decide in consultation with others that you don't need to for this particular new thing you came up with, for a variety of reasons. But if you don't at least think about it, and you then proceed and you invest money and you create something and you start potentially selling a few units here and there, talk to people and so on, it might be too late if you later decide that you want to get a patent. Rights that are lost can be irretrievably lost. So if you're going to get a patent, usually you have to file that application very early. So at least think about it.
Okay. I want to talk about a little bit about filing patents that have value. So first of all, Gene, you were talking about make sure if you're going to file something that you can do a little bit of homework to make sure that it has value and that you can monetize it. That makes perfect sense.
Right.
And if it is successful, there's a very good chance you probably will get copied. That's probably pretty accurate today, correct?
Absolutely. I mean, that's very true. And I see in the comments, somebody has said, all this is fine until you hit the home run and then you get copied. Well, frankly, Stephen, you want to get copied, don't you? I mean, if you're not getting copied, then that means you haven't been successful, right?
Yeah,
I mean,
I always tell everybody, if you're copies, congratulations.
Right. I mean, because nobody copies something that's unsuccessful.
Okay. So there's ways to fight back. And that's what I'm all about is, look, it's business is tough, right, and it's called competition. And if you want to fight the battle of words in a patent, you can, right? But there's other ways to fight back. But I want to talk a little bit about the prior art for just a minute.
Sure.
Because I think the more I understand some of the issues, especially if it comes to some type of litigation, it always comes down to prior art. So is there anything that we can do as inventors to recognize that, hey, if I do have the home run, and maybe that someone's going to try to trip me up somewhere down the line, how important is prior art, searching for prior patents, Andrei? How important is that?
Well, keep in mind that the office itself will search, the patent office will do a search for prior arts when you apply. In my view, I think it is important for you or your counsel to look and see if, before you spend too much time or in too many resources in a particular area, to see if you really are the first. It's a big world. Keep in mind that prior art that invalidates your patent application can come from anywhere in the world. A patent itself is domestic. So you can only get a country-specific patent. You'll get a US patent or a Mexican patent or Japanese patent and the like. But prior art is international. So prior art from any country, any written document anywhere, or a prior invention anywhere in the world can be used, generally speaking, against your patent application here.
Okay.
So it is it is not too difficult nowadays with automated systems. It is not too expensive nowadays with automated systems to search at least a little bit, and you'll quickly get an idea as to whether you're in the right field or not.
Okay. Hey, Gene, I want you to talk about prior art too, because I know we've had quite a few conversations about it, and you cannot find everything. We know that.
No, and it's a complicated question, right? Because when we're talking about prior art to this audience, we're talking primarily to people who are truly independent inventors. You don't have a team. You're inventing on your own. Some of you may be inventing in a team, and that makes it a little bit easier, because then one of you can work on doing the market research, the other one could work on the prior art, etc. But when it's you as a solo independent inventor, so many of these things that we're talking about need to be done simultaneously, and you obviously can't do everything simultaneously. So what you need to do is you need to move forward in a responsible way, inching forward and kind of doing these things over and over and over again, as long as the project continues to make sense. So what you want to do is you want to do at least some investigation, I think, on the prior art level, whether it's Google patents or whether it's at the USPTO or Free Patents Online. Once you first come up with your idea, to get an idea of, is this something that other people have thought about? Now, whatever prior art search you're going to do yourself is not going to be adequate ultimately, because you're not a prior art searcher, and others who do this for a living will be able to find more. But it's important for you to do it so that you can see what's out there, and you can start to understand the level of sophistication of description that needs to go into a patent, right? Okay. And if you start to see, okay, well, I'm not seeing my invention idea, now maybe take this preliminary steps forward to say, well, what's the market? Anybody interested in this? And then if that looks good, then circle back and do a little bit deeper dive in the prior art search. And this is obviously also simultaneously while you're continuing to work in your garage or in your basement to better the invention and, get better pieces and parts and, try and improve it. So what you do is you inch forward in multiple different areas. And then at some point in time, you're going to say, okay, look, this has got some legs. I've taken this as far as I can on the prior art. I've done as much as I can on the marketing stuff, and it works. The prototype, whatever prototype I have, works, or it works on paper, and I've got a decent design. Now I need some help, or I'm ready to file the provisional probably before I go out to get that help. All right. So that whatever I have now is protected.
So go a little slow, make sure it warrants it to do this.
Absolutely. I mean, I'm a big fan. I mean, and the other thing, Stephen, we talk about is setting a budget, right? I mean, because once you get into these projects, you might find that it's going to take a lot more money than you had thought, and that should maybe be the first warning sign, but for goodness sake, don't ever throw anything away. I talk to so many inventors who, throw things away. Don't. Keep it literally on the shelf. You'll be shocked at how many inventors have stories of, it didn't go anywhere this time, but then, a year later, I had a different idea, and then something I had done previously now all of a sudden was the missing piece that I needed over here.
All right. I want to jump over and talk a little bit about PTAB. I know some people are aware of it, some people are not. There's a lot of noise out there about PTAB, Andrei. We should get rid of it completely. It's bad. It's a killing mechanism of patents. What's the real deal with that? Because it is changing over the years, hasn't it? And what's the purpose of it? And is it a good thing?
Yeah, it has changed over the years. So for folks who might not know all the details, the PTAB stands for the Patent Trial and Appeals Board. It does two things. First of all, it has administrative patent judges, 250, 260, something like that, judges who are patent judges, and it does two main things. One is appeals by the patent applicant from rejections by the examiners. You file a patent application, the examiner rejects it, you go back and forth a couple of times, you can't convince the examiner then issues a final rejection. If you still think you have something valuable there, you can appeal to the PTAB, to the appellate section of the PTAB. And by the way, that appeal on average now, we got it down to about 12, 13 months. It used to be 30 months, but now the appeal takes about a year. So that's been a big improvement. So if you think you have something valuable, but you couldn't convince the examiner, go ahead and file that appeal. But that's not the controversial part of the PTAB, Stephen. The second part of the PTAB is the trials part. So the trials part, what it does is after a patent is issued, any member of the public can bring that patent back to the PTO, to the PTAB in particular, and ask the PTAB to take a second look at it, because the allegation is it was incorrectly issued, and it's therefore invalid. And then the PTAB has a trial to analyze that question. The proceedings are called either a PGR or an IPR. So a post-grant review or an inter-parties review, it depends when it gets filed. The IPRs in particular have become quite controversial, as you have mentioned. The IPR process and the PGR process was added in 2012 by what's called the America Invents Act. The AIA was signed by President Obama in 2012. So we now have about 10 years worth of experience with IPRs at the PTAB. And the reason it's controversial, Stephen, is, it's understandable because inventors and patent owners have what they think is a valid patent. They have that beautiful document that you have shown at the beginning of the hour. It's got the official seal of the Patent and Trademark Office, the director's signature, and perhaps over the years, the patent owner has relied on that patent, perhaps has built a business surrounding that patent, perhaps it has licensed it. And now, potentially years in, here comes a challenge that ultimately the PTAB decides is, the patent should not have been issued and invalidates the patent. Your question is that process good or bad? Well, look, that's not for me to say. It is something that was very hard fought in the legislative process in Congress 10 years ago. It took years to get approved by the Congress and signed by the president. And this is what we have right now. A lot of folks are upset with the PTO. The PTO is the administrative part of government. The PTO has to enforce the laws as written. It's a statute, so the PTO has to enforce the statute. What we have done, at least in recent years, is what I believe is to balance the system. Since we're going to have the proceedings anyway, that's what the statute says. I think it's important for the proceedings to be at least for the proceedings to be fair. So we have taken a number of measures to balance the proceedings. For example, it used to be that there were a limitless number of challenges that one could bring against a patent. Well, now we have said that if you are the same petitioner, you can't bring multiple petitions in series, for example. And we have also reduced the number of petitions that you can file at the same time. Things like this. We've also made it easier to amend patent claims during that process, which is something the statute contemplates. So it is a controversial proceeding and process, Stephen, but given that we have the law right now, I think we've achieved significant balance. Let me leave you with this on that point. There's a challenge to the constitutionality of the judges at the PTAB that's pending at the Supreme Court right now, any day now, and most likely by the end of this month, the Supreme Court will rule on that challenge. So it is so one possible outcome is the Supreme Court says it's all fine and nothing changes. But there is another possibility where the Supreme Court says that the judges are unconstitutionally appointed, and therefore the PTAB process will experience significant changes if that happens, potentially.
Well, I think we're all going to be waiting for that. Do you have any feelings how that's going to go? Any opinions, Gene, how that's going to go?
Well, when I try and pick what the Supreme Court is going to do in patent cases, I tend to not have a very good track record. So frequently what I'll do is I'll try and pick what's the wrong decision and then predict that they'll do that. And, I frankly, I don't know what the wrong decision is here, because there's some belief that no matter what the Supreme Court does, then Congress is going to come back and undo it and change it. So what it is it's something that's really worth watching. And I know there are inventor groups that are really watching it so that they can be involved if and when Congress does get involved. So I think that the best thing that we could hope for is perhaps that the Supreme Court does say that these judges are unconstitutional. And then that prompts Congress to want to take a look at what's going on. And then maybe there's an opportunity to get some further reforms to the PTAB. Because a lot of the great things that Andrei did while he was director are just rules. It would be great to get them instituted into the statute so that they're, can't be changed moving forward. It would also be great to get a few more things into the statute as well. But the PTAB is a hot topic. I don't like the PTAB. I think the PTAB goes too far. I think Andrei did as much as he could reasonably do to rectify the problems of the PTAB, over a very short period of time. It had been left to its own devices. And when you do that, it got stronger and stronger and stronger. And I think that some of the next director will hopefully pull back from the PTAB more. I mean, the whole idea of the PTAB is it was going to take away the really bad patents, the stuff that, examiners clearly made mistakes on, or stuff that, maybe it wasn't a mistake when the examiner did it, but after the fact, some prior arts come to light and it's like, oh, okay, well, now that we found that, this patent can't stand. And they just hear way too many cases, I think.
Okay.
Yeah.
Looks like I've got a question here about what are the hottest topics right now, Andrei, with patents? What is the hottest topic? Is this the one you just mentioned? Is that the hottest thing that's going on, or is there something more we need to know about?
Oh boy, there's a lot of hot topics in patent law, Stephen. So the PTAB is hot. It's been hot for a decade since its institution. I don't think it's lost any heat. So it is hot. A very hot substantive topic is what we call Section 101 of the Patent Code, patentable subject matter. And that is, the statute was written a very long time ago. It was actually written in 1793 by Jefferson and Madison. It hasn't changed since. And courts have struggled to fit in modern technologies within that 18th century statute, Section 101. So that might go to the Supreme Court as well. Again, it's gone there several times over the past couple of decades. So that topic is super hot. But there is an even hotter topic that's on the front pages of the news nowadays in the popular media, and that is the waiver of intellectual property rights, including patent rights, for COVID-19 related technologies. So from a public policy point of view, that right now I think is the hottest topic.
Now let's talk about that, Gene. That seems crazy. Why would we share those patents when they're so valuable and It takes a long time to get up to speed. It takes a lot of money. And if we just shared it with everybody else, why would anybody even come up with the latest technology in the pharma area, especially when it has to do with COVID? Why bother?
Well, that's exactly right. They wouldn't. And this whole waiving of COVID related vaccine patents is it's just it's political, it's PC, it's ridiculous. It's I really couldn't tell you what's going on in the head of the people who really believe it, because it's not going to matter. It won't matter at all. Because the reality is that by the end of this year, we're going to have 10 or 11 billion extra vaccine doses just based on the manufacturing capacity in the US. And so even if this gets waived, even if the rights get waived, it's not going to make any difference, because when the rights get waived, what it'll do is it'll let countries build manufacturing facilities to create these vaccines themselves. But they're going to be creating vaccines that aren't regulated, and these vaccines are incredibly complex to make. So it's not going to get shots in arms any quicker, and it's going to take years to build the manufacturing facilities to do this, and or train up the people to make them in the first place, because the countries that are worrying about this, they don't have the workforce to be able to make these mRNA. So what this is it's really just an IP grab. They're trying to break these patents. People who don't like patents want to get access to this information. And ultimately, I don't think it's going to go anywhere, because people are very concerned about this. And I think they're going to finally get to the point where they realize that, well, wait a minute, 70% of the world over the next 8 to 9 months has been vaccinated. What's the point?
Okay. Hey, I've got one quick question, then I want to open it up, Courtney. Is China, are they cleaning our clock here with innovation? I mean, what's the deal with that? I know years ago, China didn't care about IP whatsoever. And now it looks like they're filing a lot of patents. It looks like they're getting ahead of us in innovation. Andrei, what's the scoop on that? Are they taking advantage of us at the moment?
It's a super interesting topic, Stephen, and it's of huge importance to the United States. It's one of, in my opinion, this is one of the most important issues for the United States right now at the highest levels, both for national security and economic security going forward. China has a two-pronged approach when it comes to intellectual property right now. First, China is stealing our intellectual property through all sorts of mechanisms, for example, counterfeiting, piracy at unbelievable scales, hundreds of billions of dollars a year in counterfeit and pirated goods from China and its territories, forced technology transfers, outright copying, and the like. So that's path number one, and all of that has to stop. And the prior administration, and I think this administration will continue to apply pressure together with our trade partners to stop those nefarious trade practices. But second, and somewhat counterintuitively, China is also increasing its own domestic intellectual property protections. So China is improving its laws and also encouraging its companies to file more and more intellectual property, patents, copyrights, everything, both domestically in China, but also internationally. So what we see right now is, whereas about 10 years ago, you couldn't find China on the scales of the number of patent applications, it was at the very bottom. Now, China outpaces everyone in the world, including the United States, in the number of patents, patent applications, trademark applications, and the like. It's not even close. It's not even close. So that is a result of their increased patenting and just applications, but also an increased attention to innovation. They have told us what they're interested in. They were nice enough to tell us in their Made in China 2025, 2030 plans. They told us the areas of technology they're interested in, such as artificial intelligence, biotechnology, quantum computing, advanced materials, and so on. There's a list. and they are singularly focused on leading the world in those technologies of the fourth industrial revolution. In some areas, they've already outpaced the United States. 5G is an example. In other areas, they're neck and neck with us. Artificial intelligence, we can still prevail, but we got to get going because the competition from China is fierce in these areas of technology. It is critically important for the United States. We must focus as a country, and we cannot relinquish our technological lead. We must invent more. I'm glad to see so many inventors on this call. We need all hands on deck. All inventors and more need to keep inventing, and we all need to support their efforts.
Thanks,
Stephen, can we go back to, the whole COVID-19 thing? You can't divorce China from that either, because it's not just a patent waiver. It's a trade secret waiver as well. And the Chinese have historically required, in order to do business in China, companies to give over their trade secrets, right? So now, if this waiver gets passed, countries could require these biotech and pharmaceutical companies to lay open their trade secrets in order to have access to their marketplaces. Now, the reason that's really a concern in places like China and other very large countries is these companies are not going to walk away from 1.8, 1.7 billion people. And we know that they've already shown the willingness to make very, I think, bad business decisions with their intellectual property in order to get access to the Chinese market that has made it easier for the China to get advanced so quickly and so rapidly in so many different areas. So this waiver is a real concern on many different fronts, and people really need to be worried about it, I think.
Hey, let's jump in with some questions, you guys. I know we're going to go a little bit long here, but because this conversation, I could continue this all afternoon, but we don't have all afternoon. Courtney, do you see a couple good questions there? I'm sure there's a lot, and we're not going to get to everybody, of course.
Yes, there are a lot, and we've got some really good ones on a very large variety of topics. So let's go ahead and kick it off with Nick Clausen's question in relation to existing patents and transferring ownership. Nick, I'm going to go ahead and unmute you, and you can go ahead and ask that question.
Yeah, absolutely. Thanks for hopping on, you guys. My question was based around like how to get the most value out of a patent. So say a company has an unused patent on their books, or an individual has a patent without the product being produced yet. Where does that value in that patent come from? Is it about finding the right buyer, and then how do you do that?
Whoever would like to answer, go for it.
So are you talking about like a company, or are you trying to talk about like when you're approaching a company for a licensing deal?
Right. So kind of two fronts. One is an individual that has a patent that hasn't been producing the product yet. And then also say a company wants to transfer their patent to another company, but doesn't know what the value of that patent is to another company.
Right. So the real value for a company with respect to dealing with you guys as independent inventors is that you will have demonstrated to a certain level that this thing exists, that this thing works, that you've had an idea. Once upon a time, companies didn't like taking outside ideas. Now companies know that they can't survive without taking outside ideas, and they need fresh new ideas because they don't have a monopoly on them. So there are a whole lot of companies that are looking for good ideas that are out there. Now, you might say, well, why don't they, after I tell them, why don't they just copy it? Well, a reputable company is going to find it much easier to work with you once you have established your rights in a form of a provisional than to walk over you and try and steal it. It's bad PR, it's bad press. And if your established rights are decent to begin with, that gives them a foundation to build on ahead of others who might be wanting to go down that path and then copy them once they would release it. Okay, so that's what they want to do. So another part of this too is not just that are they going to get the patent from you, but are you going to be somebody that's easy to deal with? I mean, if you walk into these licensing negotiations, like some inventors say, well, I'm coming with the idea, so I want 90% of the royalty. Okay, well, that's never going to happen. That's just not going to happen. So you have to be realistic and understand what it is that you bring to the table. And you're bringing like a small piece of the front end, and then they're bringing the manufacturing, and they're bringing the distribution, and they're bringing all the customers. Okay, so it's a relationship, but it's going to be easier for them to deal with you than it is to just roll over you. Now, when a company is taking a patent and acquiring it from another company, usually it's not going to be just a single patent. It'll be likely a portfolio, and they're going to be going into an entire line of, and probably going to acquire more than just the portfolio. You probably acquire the line of business now, but the whole line of business is probably not nearly as valuable as the portfolio. The patent portfolio, and the company probably has an idea of what they want to do anyway, and they find a need for that particular portfolio. I don't know, Andre, whether you have any thoughts on that. I know you've done some stuff representing companies in the high-tech sector where patents have moved in different directions.
Yeah, no, I think what you just said, Jen, is the right thing to do, and the way to think about it if you're trying to license your technology out to try to get the company to start using and making your product. It could be, though, Nick, that you have a patent, and as I understand your question, you haven't yet made it yet. But it could be that somebody else is doing it without your permission, and you can look and see what's out there. And if you see that somebody is doing what you actually have invented, well, then obviously you can try to enforce it against them and obtain royalties from them through litigation, as if needed. But
Oh, go ahead. Well, what I was also going to say is the one thing too that you can offer sometimes is if you have sold it, don't think about rushing off to China to get it built, or Vietnam or Mexico. Think about getting it built here in the US, and don't worry about making money on the first run. If you lose money on your first run, that's not money that's lost. That's marketing money. Because if you're going to get a small run and you're going to try and sell it, what you're trying to do is see, is anybody willing to buy it? And that's a big first hurdle for people, your companies that are going to be interested, because they don't know whether anybody wants to buy it. But if you can show up with the deal and say, hey, I had 100 units and I bought them here in the US, so they weren't priced appropriately, but they weren't sourced appropriately for a price point, but I priced them appropriately, and I sold them all out in the first week, or whatever. That's good information to pass on. So what are you passing on to the buyer?
Wonderful. Thank you so much, Nick, and appreciate the fantastic answers from both of our speaker and our moderator here. Let's go ahead and go to the next question, which is from James Allen. James, I'm going to go ahead and unmute you. You've got a question in relation to disadvantages of the individual inventor in the system here. James Allen, you can go ahead and press the unmute button. No worries at all. I will go ahead and ask your question. James's question is, what can be done to reduce the disadvantages of the individual inventor in the system, something like the public defender in a criminal trial? I don't know who would like to answer that.
I can start. There's no question that the individual inventor, the individual with fewer resources, is at some disadvantage in the system, simply because the system is complex and can be costly to navigate and the like. But it depends on what stage you're at and in the process. So during the patent application process, there's all sorts of help an individual inventor can get. If you can afford an attorney, you can hire an attorney or a patent practitioner to help you navigate the process. If you can't and you need to go at it alone, you go to the USPTO website, uspto.gov, and you will find resources, a lot of resources in your state in your potential city that can help you. There are inventor groups that can help you. There are attorneys, depending on your financial situation, that can help you pro bono, in other words, without fees. Or if you need to apply directly to the patent office by yourself, there's what's called a pro se program, where there are dedicated examiners at the patent office that have a lot of training and a lot of patience to help you navigate the process and answer all of your questions. There are also libraries that you can find that are PTO trained librarians, and they can help you navigate the process. And you can find those libraries as well on the PTO website. If you are now in litigation down the line, all right, so somebody's infringing your patent and you need to enforce your patent against them, and you don't have resources, all right, well, there are plenty of lawyers that work on what's called a contingency, and it depends a lot on the value of the case and how good your case is and all of that. However, there are lots of lawyers out there that can help you on contingency, which means generally that you don't have to advance any fees, and you, the lawyer gets paid, if successful, at the end of the case from whatever the recovery is. There are also what's called litigation funders out there. These are financial institutions that can help you fund a litigation. It's similar in concept to the contingency that I have described. So in any event, those are just some thoughts. I don't know if Gene has other thoughts with potential help that inventors can get.
Yeah, the one thing to point out is that the contingency representation, which had completely gone away for a long time, is coming back in a larger way right now, and the funders are coming back into the industry. Now, the funders tend to like to have portfolios. They don't like to have one patent and fund one patent litigation, but there's more and more contingency litigators that are out there. So, you know, I think it's going to get a little bit easier to find those if you have a good, strong patent and there's some good infringement. It's bad infringement for you, but from the patent litigator standpoint, it's good enough infringement to get involved. I mean, because you know.
Yeah, that's a very good point, because I had the pleasure of defending my intellectual property in federal court against a little toy company, Lego. And my attorneys took it on a contingency. And that was extremely helpful. But you're right, it has to be some value there to them. There has to be, it has to be a big enough deal to where they'll take it on. So I'm glad that's coming back, because I heard that kind of disappeared for a while. So that's really good news.
Totally disappeared, and it's really coming back over the last 6 months. And somebody's asking about, you know, referrals. I know the funders. The funders aren't going to be interested in independent inventors. I don't have the names right now of the contingency lawyers, but I'm hearing that there are getting back into the industry. So what I would do is, you know, do some digging on your own. You may be surprised at who you might be able to find.
Good news. Thank you.
Great. So we've got lots of questions, of course. We are at the hour. There are two really good questions I'd love to get to. Let me go ahead and see if I can unmute Cheatham. You have a very fascinating question, in my opinion, about prior art searches, and I would love to go ahead and unmute you, and you can go ahead and ask your question.
Okay, can you hear me?
Yes, we can.
Yep.
Great. Hi, Stephen. Hi, Gene.
Hi, how are you?
I'm doing fine. How are you?
Good to see you.
Yeah, great seeing you too. Of course, Stephen's been a huge advocate, and Gene early on was very helpful. I actually talked to him, and he advised me, gave me some guidance on this particular patent I'm working on. So thank you for that, Gene. That was very
problem.
But
I was glad to see you're here.
Yeah. So where I am is I've submitted an application. So it's been prosecuted, had working on the second, we responded to the second final, office action, had an interview with the examiner. And what we're stuck on is that when you were talking about prior art, so you need to know what's out there to know whether your idea is patentable or not. So what's happening with mine is it's not individual prior arts, they couldn't come up with anything. So they found two, the examiner did. And they're two very unrelated. It doesn't make any logical sense. My lawyer agrees with it. And that's what's holding up. So what they're saying is there are these two totally unrelated prior arts. And what they're saying is that somebody, skilled in the art could have seen those two and come up with my idea. And these patents have been out there for years, and clearly nobody's come up with it. But they're saying because of that, it's obvious. So my product is not in the market, and it's being held up for like two unrelated reasons. And we're still pursuing it. We're probably going to go to some level of appeal. Or,
I want to hear Andrei's opinion on that too,
Yeah.
because that's not fair, but go ahead, Jean.
I don't think it's fair.
Well, obviousness is sort of before we got all worked up about 10 years ago about 101 and patent eligibility. Obviousness was becoming the real bane of the existence of all inventors, because it started to become on steroids, and it was like examiners, it feels like in a lot of cases, just wave their hands and say, oh, this is obvious, almost like it's that scene from Star Wars. These are not the droids you're looking for. It's like these references make your invention obvious. It's like, well, why? Explain this to me. I do think the rules that we have, and not to say, and I don't know who your attorney is, and I don't want to say anything bad about attorneys, but a lot of attorneys sometimes don't like to be confrontational. Under the rules for obviousness, the laws for obviousness, you do have the ability to force the examiner to explain their reasoning. Because the examiner can't just wave their hands, and a lot of examiners do want to just wave their hands. And if these are very unrelated, why would somebody put these things together and find that it would be predictable? Because the whole question is it predictable? And they've got to explain themselves. And frequently in these things, they don't explain themselves. And if you don't force them to explain themselves, they're never going to explain themselves. Now, the other thing that they may be dealing with is you might be dealing with an examiner who might want to see you file what's called an RCE so that they can get a little bit extra time to work on the case. And that's they might be trying to game the system a little bit doing that. I don't know whether that's the case or not.
Well, so we did file an RCE. So if that's what they wanted, they got it. And she has explained it. She's explained it in like many, many pages, but it doesn't make sense. They met with her and that didn't make sense. And she responded again. So she's already responded to the RCE like within days. But what she did was she took these two prior arts, merged them together, and now the functionality of each prior art has changed. So what they were about, and by the way, mine's a utility application, and these prior arts are design. So she's taking two design patents, merging them together, and each one now doesn't function the way they were intended. And she's saying that's obvious.
Yeah, those patent examiners just aren't fair, Andrei. Why is that? Why aren't they more friendly? Help us.
Well, look, as a general principle, I think examiners are trying to do their job. But Jigdam, I think what you're describing, I'm fascinated by your question and the way you're proposing it, because the answers to your own question are built into what you have already said to some extent. You've come up with your arguments on your own. So look, combining two references, or even three sometimes, as it happens, to reject a patent application under obviousness considerations, that's 35 USC section 103. Okay, that happens regularly at the Patent and Trademark Office. There are many arguments you can make against it, and you've identified some of them. They're unrelated, Mr. or Miss Examiner. They should not be combined. As a matter of fact, you would say, if accurate, they're in unrelated fields, and therefore one of ordinary skill in the art would have no idea to combine them. It wouldn't even occur to them to combine them. And furthermore, you might argue, if appropriate, if you do combine them, you are destroying each one of them, for they're no longer going to work for their intended purposes. And you have also mentioned another very good argument that depending on the facts of the case, which is they've been around these other patents for X number of years. How come nobody has thought about combining them if it was so obvious to do so? That's what's called a secondary consideration of non-obviousness. So my suggestion is talk to your lawyer again, try to go back again. If you personally have not met with the examiner, if you're the inventor, I take it, you're the inventor, named
Yes.
inventor, have you met with the examiner?
I haven't, my lawyer has.
Well, sometimes, examiners like to hear directly from the applicant, from the inventor. The way I've heard you talk right now, I think you are very capable of expressing, directly what your feelings are about this. And an inventor is, by definition, one of ordinary skill in this particular art. So they should listen to you. Another thing you might consider, talk to your lawyer and think about potentially getting a declaration from an expert, a third party professor someplace in your field of use here, and that might put in a declaration to support your point of view and explain why it's inappropriate to combine those things. Your lawyer should be able to guide you through all of those issues.
Can I ask one more question? Because my lawyer gets it and he agrees it's inappropriate. And let me just clarify, the two prior arts are in the same industry, but merging them doesn't make any sense. That's where it's illogical, and then the functionality changes. So my impression of, because I've seen what this examiner writes, and it's very illogical. And my thought is that there's nothing we can say to change this examiner's mind. She just seems to be, she's not like, from the very first filing, she hasn't moved an inch. So my question is, how do I, and I'm going to talk to him about, because my lawyer did say the next step would be for me to talk to the examiner. I'm just concerned that we're going to meet with her and she's not going to move at all. Meanwhile, I'm spending a lot of money.
So you don't know. You don't know. And nowadays, it's fairly easy to meet with examiners. They do it by video conference, especially post-COVID, or a phone call. So the inventor speaking to the examiner sometimes helps. Not always, but sometimes it helps. If you continue to believe you are right, and the examiner is just not budging, you can ask to speak to the supervisor. This SPE, the supervising patent examiner, is available if you think the examiner is inappropriately intransigent in her position, and see where that goes. Ultimately, if you make zero headway and they issue a final rejection and you continue to think you're right, as I mentioned, you can appeal. Always good to have a full record before you close the case and go on appeal. So if you're going to do a declaration or the like, good to put in ahead of time.
Yeah, and the thing that I don't understand, I mean, you can use design patents to reject a utility application, but I'm thinking, I don't know that I've ever seen two design patents used in combination to reject a utility application. I mean, how would anyone of skill in the art know exactly how to put these two things together in the same way that you've done? I mean, because there's no writing or almost no writing in a design patent. So it seems like the examiner must be introducing an awful lot of her own opinions and thoughts. So I would try and get her to explain that to you when you meet. And I'm a fan. I don't know. I'd kind of like to know what you think of this. A lot of times, when you talk with the examiner, you always have to have the examiner interview summary. And historically, those are like just one line. The interview was conducted on X date, no agreement was reached, period. I think that when you're dealing with an examiner, particularly that you don't think is giving you a fair shake, that having a little bit more detailed examiner interview summary can be helpful. What do you think?
Well, boy, Gene, that's a long, complicated question. As a litigator, as a general, at a high level principle, yeah, I prefer not to have that in.
Yeah.
because I don't know what the examiner is going to say. And you're going to have to use that file wrapper years down the line, and you don't know how it's going to read in a particular lawsuit years down the line. But I can see the value, and you can make that decision in a bit more of a, based on a bit more knowledge after the interview, because you'll know after the interview generally where the examiner's head is. And if you think the examiner is going to say something helpful for the file, you might want to ask for that. But otherwise, if the examiner is going to say things that are not helpful for you.
Oh, no. Yeah. It's got to be self-serving. It's good that if you're doing that, it's got to be self-serving. Yeah. Okay.
Wonderful. All right. Thank you so much. We really appreciate all those questions being answered. Of course, we are out of time here. So with that said, I'm going to remove these spotlights here. All right. Feel free. Everyone can go back to gallery mode. With that said, everyone, please type in your thank yous to both of our moderators as well as Andrei Iancu. We really appreciate them spending a little bit of their Saturday here with us at Inventors Online here. I would like to briefly do something a little bit different here. Completely brand new for Andrei and Jean. I would love to have just a really quick round of applause from everyone in the audience for just thanking them for coming here. I'm going to go ahead and unmute everyone for about 10 seconds, and let's just give a wonderful big round of applause to everyone. So, all right, I'm going to go ahead and unmute everyone. Let's go ahead. In 3, 2, 1, go ahead and click the unmute button.
Thank you. Oh, thank you. Thank you. Bye.
Wonderful. Thank you everyone so much for going ahead and doing that. Let me go ahead and unmute back our speakers here. Always fun to try some new things. All right, looks like I got everyone back here. Wonderful. Okay, so with that said, Andrei and Jean, from behalf of Inventors Groups of America, I would like to deeply thank all of you for your hard work that has not gone unnoticed. It was an honor to have you both speak to our audience today on a Saturday, and it really does show your dedicated, diligent, and thought-provoking nature in the important topic of patents and IP. We really need more of you too in the inventor community, and we really appreciate your honesty and your kindness. So without further ado, let's go ahead and just briefly mention the giveaways here. Let's also do a little family photo. So everyone go ahead and get ready to have like a big smile here, and let's go ahead and screenshot all of the screens here. All right, here we go. And 1, 2, 3, let's have everyone smiling. All right, let's go ahead and do this next page here. 1, 2, 3. Got a lot of pages here, so let's just keep those smiles going. All right, looks like we're on the last page here. Nope, one more. Here we go. Okay, looks like we got everyone. Okay, so with that said, for our free virtual swag, of course, Stephen's book, Sell Your Ideas With or Without a Patent, is free today on Kindle until the end of the 20th, tomorrow on Sunday. Just go ahead and type in Sell Your Ideas With or Without a Patent on Amazon and click on the Kindle version and go ahead and download it for free. We go ahead and put this into the chat so everyone can go ahead and also follow these instructions if you want to get that book.
It's also for Kindle, but also for your computer as well.
Great, good point. Wonderful. All right, and then with that said, let's go ahead and for our 3 giveaways, after our event, we will be randomizing our audience list from today and notify you via email that you signed up with at IGA to send you the details if you won on your winnings. Let's go ahead and take a look at the various items that you can win. Once I bring this up, Stephen, if you want to go ahead and just briefly...
Yeah, I want to talk about those really quickly, everybody. First of all, Courtney had mentioned sell your idea with or without a patent. It's actually talks about provisional patent applications, which is part of my favorite tool to use, but also how to cut a win-win licensing agreement. So please get that free copy. But I also want to say, Gene, thank you very much for creating the most amazing provisional patent program. We're giving away 10 we call it Smart IP. It was created by Gene Quinn. It's a fantastic job. It shows you how to write a provisional patent application that actually has value. Gene, it's absolutely awesome. So thank you very much.
No problem.
Also, Jake Ward. I cannot thank Jake Ward enough. He's a great patent attorney. He's inventor friendly. He gave us the ability to give away one winner only for a patentability search by his office. It's got a great value of $800. Please thank Jake. He does a great job. And if you need any of his services, he's the great guy to find. Also, Kevin Prince. I've known Kevin for over 20 years. He's inventor friendly, started the Orange County Inventors Group. He really does a great job. I use him all the time. He's giving away a review of your provisional patent application, which is really awesome to do that because we always wonder, did we do it right? And Kevin's going to make sure that we've done. It's a value of $395. I just want to thank everybody that came today. I want to thank Courtney for doing also a great job. Andrei, what a pleasure having you on tonight. Also, one last thing, please join your local inventors group. It's the lowest cost thing that you can possibly do to learn all about coming up with a great idea, meet other fellow inventors. Find that group within your city, join these guys that put these groups together. They're angels and they support you. So please support your local inventors group. They're part of this whole network of inventors supporting each other. And I just want to thank everyone, Gene, Andrei, Courtney, and the group for coming out on a Saturday. Thank you very much for doing that.
No problem, Stephen.
We really appreciate it. Any final thoughts, Gene or Andrei, before we leave?
What I would just say is if you're not near a local inventors group, start your own local inventors group. I mean, it is a great way to meet like-minded people and to stay engaged and energized. And you might find somebody you could work together with under appropriate NDA always, but they're great to be surrounded by like-minded people. The energy at inventors groups is contagious because we spend so much time with people who will tell you, no, that's not going to work, and maybe it won't work, but you need to surround yourself with people who dream the dream like you dream. And inventors groups are great places. I can't speak highly enough about them.
Wonderful. Andrei?
Well, I'll echo Gene's thoughts about inventor groups and doing programs like this. But I want to end by saying thank you to Stephen and to Madeline and to Courtney for putting this program together and inviting me to be here with all of you. Thank you to Gene. Always an honor to be with you. We've done many programs together. Always really a fascinating conversation. So much good advice from you, Gene. At all times, including today. And for all of you, keep doing what you're doing. You are at the forefront of innovation. The United States, and if you're in other countries, the countries you're in, the world needs more and more inventors and the work that you all do. So keep it up. It's really an exciting field. It's one of the best fields to be in my for sure unbiased opinion, and I look forward to seeing great successes coming out of all of you.
Yeah. And thank you, Stephen, for hosting this great meeting. I mean, you guys are quite lucky to have an industry rock star like Stephen. And what I always like about Stephen is, unlike so many of the others out there who are inventor coaches and have inventor groups like this, Stephen has actually been successful at getting patents, and he's been successful at monetizing the patents, and that's what you got to look out for. Getting a patent is one thing, but when you've been as successful like Stephen and actually making money on the patents, you guys are listening to the right person. So thank you, Stephen.
Thank you so much, Gene. Everybody have a great weekend. See you next month. Thank you, everybody.
Take
Have
care.
a good day.
Wonderful. Thank you, everyone. Have a wonderful night. We appreciate it, Andre and Jean and Stephen, for speaking with us today. Our next meeting is coming up soon on July 28th. The only hint I will give you is I recommend bringing your pets to the meeting.
Oh,
Once again, thank you, everyone, for speaking with us today on the weekend. Stay tuned for our next meeting so we can bring you more expert information in the areas you need help in. Thanks again, everyone, and have a wonderful weekend. Bye.
thank you, Courtney.
Bye.